maybe peoples, but maybe not the same right of self-determination as other peoples. So they wanted to qualify that self-determination that relates to indigenous peoples. Again, that's discrimination. Again, they're forbidden by their own charter, the UN Charter, to do that. So that took some time again. So if you read Article 3 in the UN Declaration on Indigenous Peoples, there's no qualification. Indigenous peoples have a right to self-determination by virtue of which they can determine freely their political status and freely pursue their economic, social, and cultural development. Period. There's no qualification. So that took a while to negotiate as well. The third element that was difficult to negotiate during those 23 years are the articles that relate to lands, territories, and resources. And I don't think I have to explain why that was difficult. There's a lot of vested interests in our lands, territories, and resources. So Articles 25 and following under the UN Declaration on the Rights of Indigenous Peoples were probably the hardest to negotiate. So if you read them carefully, you'll see the delicate balance that we have to achieve between our rights to our lands, territories, and resources, and the rights of others that live in those territories or on those resources. So there's a delicate balance that was required there. And by the way, the UN Declaration of the Rights of Indigenous Peoples is probably the most well-balanced international law document that exists today within the UN system. There are 14 articles among the 46 in the UN Declaration that have that delicate balance between our rights and the rights of others. There's 14 of them. So it's the most balancing instrument in international law that exists today. It was done on purpose. Every article was negotiated with an example in mind throughout the world. Every article, you can find an example throughout the world in which indigenous people live or experience. And when we negotiated, for instance, Article 46, which is the provision of balancing between the rights that are enshrined in the UN Declaration and the rights of others, is Article 46, paragraph 2nd. And we had in mind, when we negotiated that, the words of former Chief Justice of the Supreme Court of Canada, Justice Lemaire, who said, I believe it was in Delgamo, said at the end of his ruling in Delgamo, he said, we are all here to stay. Meaning that the non-Indigenous that are in our territories and our lands are there to stay. So we need to find a balance between our rights and their rights that exist in our territories. So that's the balancing provisions that we have to negotiate throughout the UN Declaration. And so those were the main challenges throughout the 23-year process. When the Human Rights Commission and the UN Human Rights Commission, because after the working group, when it was done and adopted by the working group, we sent it through the regular process, and it arrived before the UN Commission for consideration in June of 2007. The UN Human Rights Commission has to adopt a document before the General Assembly can consider the document. So we passed that test in June of 2007. And it was sent to the General Assembly, which was supposed to happen, which happened in September 2007. The General Assembly was called upon to consider the document in September 2007. Between June and September 2007, what happened there is also important. During those 23 years, of negotiations and drafting of the UN Declaration, there are two blocks of countries that did not participate in the process. It's the Asian bloc, because they don't recognize their indigenous peoples, and the African bloc. Although the African Commission recognized indigenous peoples in Africa, Maasai, for instance, in Kenya, are indigenous peoples in Africa. So these two blocks make up the majority of the General Assembly. They make up the majority. So they're called upon to consider a document in September meeting of the General Assembly without even having participated in the process. So they were asked to consider a document that probably didn't know existed, probably didn't know about the history of the document, but they were going to vote on it in September. So the lobbying effort that went on between June and September was an important one because of that reality that these two bloc of countries made up the majority of the General Assembly. I can tell you one thing. The four countries that eventually voted against the UN Declaration on the Rights of Indigenous Peoples in September 2007, Canada, the US, New Zealand, and Australia. I can tell you that they put a lot of resources and effort to convince these two bloc of countries to vote against the UN Declaration. Because one of the things they said, well, it threatens the territorial integrity of your countries if you accept this document. So we had to put in the same effort of lobbying these countries. I went to New York to meet with ambassadors 72 times between June and September to explain the document, to respond to their concerns, or answer their questions. So obviously, even on that field of lobbying, we won because the General Assembly overwhelmingly voted in favor of the UN Declaration in September 2007, with 4 countries against and 11 abstentions. Russia intended to vote against the UN Declaration, but at the last minute decided to abstain rather than voting against. So we only had four countries that voted against. So we won that lobbying effort. There were very few of us. The Grand Council was fortunate enough to be able to provide resources for us to do that kind of work. So this is how that process happened. And Article 38 of the UN Declaration calls on member states to adopt and implement the UN Declaration, even legislatively. That's Article 38 of the UN Declaration. So here's where I come in. As members of Parliament, each member of Parliament is allowed to introduce private member's bill, which has the same status as a government legislation, by the way. It's more difficult because it's a private member's bill, it's not a government bill. It's more difficult. The process is a bit harder because we have to convince 337 others in the House, or 338 now in the House. So it's the work is more difficult. But I thought it was important to do it because it's sort of it's personal in a way for me because it allows me to bring back the UN Declaration within domestic law and to make the UN Declaration law in this sense. You know, we have provisions under the Constitution of Canada that recognizes Aboriginal and treaty rights. But what is contained in those Aboriginal rights is anybody's guess. It's anybody's guess. Over the years, the Supreme Court has defined some of those rights under the Constitution, what Aboriginal rights mean in this country. But we're not exactly sure what they are. My bill allows to clarify. The UN Declaration provides for economic rights of indigenous peoples, political rights of indigenous peoples, cultural rights of indigenous peoples, social rights, environmental rights, spiritual rights of indigenous peoples. They recognize our spiritual connection, our distinctive spiritual connection to our lands and territories, our provisions that affect our Article 25 is a good example of that. So it provides for a whole range of rights. It also provides for the free prior and informed consent of indigenous peoples whenever development happens on their territories. Mind you, and I must say this, mind you, the UN Declaration does not create new rights. These are inherent, existing Aboriginal rights. It does not create new rights. So I think that's important to remember. Consent is a concept that has been discussed by the Supreme Court for many years, even before the UN Declaration was adopted. And I'll give you a good example. In 2004, in the Highland Nation case versus the Department of Forestry in BC, in that ruling, the Supreme Court said, on important matters, we need the full consent of indigenous peoples before development happens. The full consent, that's their words, not mine. So the term, the concept of consent already exists in constitutional law. Reconciliation, we heard a lot about it lately since the report of the Truth and Reconciliation Commission. Well, the Supreme Court has also dealt with that concept of reconciliation for many years before the report of the TRC. In that same case, the Highland Nation case in 2004, the Supreme Court says, talking about reconciliation, the objective is to reconcile the pre-existing sovereignty of indigenous peoples and the assumed sovereignty of the Crown. The assumed sovereignty of the Crown. I like that. So that's what reconciliation is all about in this country. And that's what my bill is proposing. I had a similar bill in the 41st Parliament, so the previous Parliament, before the last election, which all parties in the House voted in favor, except the Conservatives, even the Liberal Party voted in the previous Parliament. The Conservatives decided to vote in bloc against my bill, the previous bill. So I lost by 17 votes on second reading. So basically killed the previous bill. But everybody knew I was going to come back with a bill if I got reelected. And I got reelected. And I reintroduced a new bill with certain modifications because developments have happened since then. For instance, the Truth and Reconciliation Commission submitted a report about a year ago, more than a year ago, with 94 calls to action. 94 calls to action on which every party, political party in this country, every province committed to accepting the 94. The two important ones, in my view, among those 94 calls to action are 43 and 44. 44 calls on the governments in collaboration and cooperation with indigenous peoples to develop a national action plan to implement the UN Declaration on the Rights of Indigenous Peoples. 43 calls on the government of Canada, the provinces, the territories, and the municipalities to fully adopt and implement the UN Declaration on the Rights of Indigenous Peoples as the framework for reconciliation in this country. That's what my bill proposes to do, to implement 43 and 44. Throughout the last campaign, federal election campaign, I think all parties except conservatives have committed to endorsing all 94 calls to action and implementing the UN Declaration on the Rights of Indigenous Peoples. I've heard Justin Trudeau mention it many times during the campaign and since the election. My party, the aNDP, did the same. I've even committed, if the aNDP had won, if the aNDP government did not follow through with that commitment and promise, that it would lose me. That's how serious I was with the UN Declaration. So the Liberal government has promised to fully adopt and implement the UN Declaration on the Rights of Indigenous Peoples many times since the last election. What my bill proposes to do is exactly what they're saying.